So there's 3 age categories after 50: closely approaching advanced age, and closely approaching retirement age. And it's important because and just from a big picture standpoint for potential clients or people who are just listening, clients that, I guess not lawyers that we're trying to train, but the older you get, it becomes a little bit easier to win your Social Security disability case. Right. If I was just to give it a blank general summary, right? So good morning.
Good morning, Peter.
Well, actually, it's good afternoon. Somewhere in the world it's morning, and somewhere in the world it's afternoon. How are you, Jack?
No complaints. How about you, Peter?
Well, I'm a little under the weather, so you're gonna have to forgive me. But I really wanted to sit and chat with you about this topic. I find it fascinating and interesting. It's one of those topics I don't know if you have to deep dive into it with clients that we represent within Social Security. But I do think it's, for some clients, they might find it extremely fascinating. At the last time we met, we talked about the 9 things to sort of do to prepare for your Social Security disability hearing. And one of them we mentioned was understanding who's in the room, who's in the hearing with us. And one of the things you brought up was a vocational expert who's in about 90, just best guess. What percentage of the hearings are vocational experts in your hearing?
More than 90%. If there's no vocational expert scheduled, there's something funny going on with the case, and you got to look at it hard.
Right. And we use the acronym VE, vocational expert for short. So we may pepper that in. And so I wanted to, kind of do a basic general conversation and kind of dive into it a little bit deeper about who is a vocational expert, and what is their form and function, and what do they do? And I thought, with your hearing experience and, perfect person to talk to about the vocational expert. So let's chat. Why don't you tell whoever's listening, whoever our audience is that is curious about a vocational expert, a little about who is the vocational expert?
All right. Well, that's 2 parts of the expression, vocational and expert. And some of this might be a little bit obvious to people who are listening, but expert witnesses do something different from when our clients testify. They're testifying about their own lives. The basis of the testimony is their own 5 senses and memory. They were there for the subject matter of the testimony, and that's how they can testify about what happened. Expert witnesses, they're not there to say what they saw or heard. They're there to give the court some sort of specialized or scientific or technical information that they get from some sort of education, training, or professional practice. A lot of them are scientists. The example that comes right to mind to a lot of people is in criminal cases. People know from TV and the movies, the guy from the state lab who testifies about blood evidence or fingerprints. These shell casings come from this pistol the state police asked me to look at. I matched this with that under the microscope. That guy never saw a crime. Someone gives him a piece of evidence that's been collected, and he studies it so he can explain it. Doctors to explain illnesses or injuries. We'll probably do another segment on medical experts who testify in this court. Engineers to testify about how a piece of equipment fails and causes an accident. The famous one, everybody knows this movie with Joe Pesci, My Cousin Vinny. Marissa Tomei testifies as an expert on automotive mechanics. And it's a good illustration of what these people do. They know something we don't. They're not being asked to say what they saw or heard. They're asked to explain what somebody else saw or heard. So they're scientists of some kind for the most part. Vocational experts. There is a science, jump in because you know this at least as well as I do. Vocational experts are job scientists. When you consider it from a scientific point of view, their field work happens on job sites and in workplaces of all kinds. They go to these places and they make observations about how people do their jobs. They review business and industrial records. They interview people. They test and examine the materials and equipment they use. And then they take all sorts of government statistic sources about employment and labor. Like other scientists, they argue about all this stuff, and they analyze it, and there's libraries full of this stuff. Some of these guys have PhDs. We were talking about this before we came on today. The credentials seem to be a little bit loose. And as a result, some of them seem to take a scientific approach, and some of them are maybe a little bit different. But I think that's an answer to the question, or at least the beginning of one.
Yeah. I find that most of the vocational experts we run into at least have a college degree, if not a master's degree. I couldn't find at my fingertips what degree was required. And then it looks like they have a certification as well in vocational training. And then a lot of them report or to be kind of an expert in the Dictionary of Occupational Titles, or the DOT for short. And so what I wanted to ask you a little bit about is sort of the format of in the hearing of itself, which we've talked about before, but what is the format or the outline of the vocational expert's testimony? So if I'm a claimant or a young lawyer that you're training, and you're trying to prepare me of what it's going to look like, can you walk us through what a vocational expert's outline typically is in a disability hearing for Social Security?
Sure. First, we just got done talking about credentials. All experts have to be qualified one way or the other. It's generally not an issue. Their credentials appear in the file. But if you want to be thorough, you got to check it out. It's rare that an expert doesn't get qualified in this court, but it's cross your T's and dot your I's. The vocational expert will then classify your work history, what we call your PIW. And this is something we got to break down a little bit, of course. Classification. We talked about these people being scientists. There's this whole taxonomy or science of classification of jobs. When they study anything, they analyze and classify it, put it into different categories. So there are heavy jobs and light jobs, industrial jobs, office jobs. That's the kind of constellation of issues that these people are looking at. So they will discuss the work that you've done in the past based on the evidence. The skill that's required, mental complexity and stress and demands of the job on the mental side. Physical side, is it a heavy job? Do you need some sort of physical coordination? Do you need to be up on ladders and scaffolds? Are there difficult conditions like high temperatures or fumes? You got to understand what the work is like before you can understand whether someone can do it or not. And that's what these people are trained to do. Some of them are good at it, some of them are not. That's what cross-examination is for. Once they get that all classified, and I think we're going to talk about the Dictionary of Occupational Titles in a moment, because a lot of this will sound very scientific at the hearing. So they describe what the work is based on the standards that their profession uses. The second part, the judge and your lawyer will ask hypothetical questions of the expert witness based on the medical evidence. We call these RFCs, residual functional capacities, in their different views of the medical evidence. When you go through the file, and Social Security's already done this a couple of times before the case gets to hearing, but you come up with a list of limitations on the person's physical and mental abilities along all these axes we just described. How much can you lift, sit, stand, see, walk, use your eyes, use your hands, use your head? All the physical and mental problems you have because of your medical conditions. If they impose a set of limitations on your activities, what does that set of limitations look like? You put it in the form of a question. And you say to the expert, if you assume a hypothetical person with all these problems and these limitations, what kind of jobs could this person do? Guy who can't work up on a scaffold obviously couldn't be a house painter, but could he work in an office? Things like that. Now, just like lawyers, doctors know that every set of evidence might support more than one conclusion. So you do that, you formulate more than one RFC. You get more than one look at the medical evidence because the judge is going to. And you figure out if you come up with a different set of limitations, Dr. X has a different opinion from Dr. Y, so you'd ask a different question based on either one's opinion. Or someone stopped working in 2018 but got a lot sicker the next year, so a question that matches 18 wouldn't match 19. So you come up with a bunch of those questions. Try not to get too many, but they're all different views of the medical evidence. The judge will ask some, you ask some, and we're all trying to figure out what the evidence shows the person can or can't do.
Yeah. Can you give me an example of what an actual hypothetical might sound like in a hearing that you would ask of a vocational expert?
Yes, I will, and we're going to keep unpacking this as we go along.
Yeah.
You might say, suppose a hypothetical person were limited to light work, occasionally all the postural activities, frequent use of the right upper extremity for handling, finger, and feeling, occasional use of the left upper extremity for handling, fingering, and feeling, simple routine mental tasks, occasional public contact, no contact, occasional public contact. If you or I were to ask that question or a judge, we'd know exactly what that person meant. But now I think we have to unpack that. Was that what your question was about?
No, and we will unpack it. But I love that is an actual type of hypothetical question that you would ask a vocational expert if the medical records from your reading of the medical file would support that hypothetical. So, for example, you said occasional public contact. Are there mental health records in the file where a therapist or a psychologist or a psychiatrist says, this person should only have some sort of limited interaction based off their diagnoses and symptoms with the general public, whether it's due to anxiety, depression, PTSD, whatever is triggered when in the public. So it's not just like creating these symptoms out of thin air.
No.
In hand with you understanding the medical file and then being able to craft a hypothetical with certain limitations. And you said, for example, light duty. Well, there's actual legal definition to light duty that Social Security has. Before we unpack that, and I want to come back to it a little bit, what I've told folks is that, look, a vocational expert is an expert witness to talk about jobs, right? Just a jobs expert. And one of the things they do is they look at your past relevant work, and that's all the work you've done. Generally speaking, it's all the work you've done in the last 15 years. Now, there's exceptions to that. And, so for example, if your date last insured is in the past, it's 15 years from your date last insured. So it could be like maybe on some cases 20 years or 22 years or 18 years. But generally speaking, all the work you've done in the last 15 years. What, for our audience who's not represented, what form does the vocational expert, or how do they come up with the past relevant work of a client from the file without even talking to the claimant? Because a lot of times they don't ask the client questions.
Okay. Yeah. There are all these, everybody, if you're unrepresented, for sure you know about all the forms you've had to fill out. And you've probably filled out at least one form that outlines your work history, and probably a couple. There's a work history report, there's a work activity report, in your adult disability report, you've given the court a lot of information. And you'll probably recall specific questions about how much did you lift and did you supervise people and things like that. All of that gives the court a work history. Now, the other part of this is it full-time or not? Social Security, like you said, they borrow a lot. They borrow earnings records from the IRS. So they can't tell what kind of work you did, but they can tell who you worked for and how much they paid you and when. So the judge can say this job was full-time and this job was not based on those earnings records. So the expert witness will get all these reports that you have filed describing how much you have to lift, sit, stand, walk, what kind of business was it, and they'll do their best to try and come up with, try and put each of these places you've described in your work history into a slot in this dictionary of occupational titles that we've referred to a couple of times. What's the job title in there that most closely matches the evidence that I see in this file? What this guy said about the case, about his work history, what does that look like when I match it up against this text we use in our profession? Does that sound about like an answer?
Yeah, no, that's absolutely correct. I think one of the things I'll tell clients is that work history form that they filled out by hand and turned in gets heavily relied on in court. And it's an important form. I actually did a whole video on it, I think, just on how to fill that form out. And you want to be cautious because, if you go in there, and I find it, we're going to talk about skill level and all this stuff, transferable skills here in a minute, but I find it fascinating because so much from a cultural standpoint and, at least in the United States, from a cultural standpoint, when we've been so trained to sort of brag about our past work. I was a manager at 7-Eleven, right? I was the night supervisor at AM PM or Shake Shack or wherever, right? And sometimes you have to be careful because Social Security, and generally in life, like if you're interviewing for a job, sure, that's great. But Social Security will then use that against you, right? Oh, you said you were a manager? And it's and a judge isn't going to deep dive in the same way that you or I might about, well, did you manage people? No, I managed myself. I managed the store. Well, was there anyone in the store? No, it was empty, right? Were you in charge of hiring and firing? No. Were you in charge of employee reviews and scheduling and giving raises? And, so that form is important. And it's the one place you don't want to over exaggerate kind of what you've done in your past, because it actually can hurt your case. So that's one of the things I wanted to bring out about how they come up with what we call PRW, the past relevant work, and how they testify from it. Now, one of the things he talked about was the DOT. Can you give us a little bit of information about the Dictionary of Occupational Titles, or, when it was created, what it is?
Yes, I can. So we talk about vocational studies as a science, and it has a central text, at least here in this country. It's called the DOT, the Dictionary of Occupational Titles. During the Great Depression, the U.S. government started formalizing the study of labor studies, what's now vocational studies. So they wanted to make a scientific approach to studying how people work. And so this was the beginning of this science, and they found a way to classify different jobs, and they decided they wanted to put them all together in one authoritative text. It's called the Dictionary of Occupational Titles. It was first published by the Department of Labor in 1938. It's been updated a few times since then. It's supplemented now. But what the original intent, every job in the U.S. economy is supposed to have an entry in this book. And every entry is a matrix of numbers that describe the mental and physical requirements to do the job full time. Now, we all use this book online, but have you ever seen a paper copy of it?
I don't think I have.
I will tell you, I saw one at the University of Maine. It's 13,000 pages. It stacks up about 4 feet high on a desk. It weighs 40-something pounds. I don't think they publish them anymore, and why would you want one? But in any event, so it's a huge book. And on top of it being enormous, it's illegible because it's all printed in numbers. It's written in this code that you need to know. So these people really are scientists. And all these entries, how much does this person need to use his hands? How much does he need to be exposed to certain job conditions, whether it's people around him or who works alone, things like that. There's more to that work, to that science, of course, but that's the DOT.
The one thing that I'll tell clients is that the DOT does a few things generally. it gives a brief so first it'll be like an example of a job might be dishwasher.
Mm-hmm.
We'll assign it like a number, like you might find in a library on a book, 424-010, dishwasher. Okay. So it assigns it a number, and then it gives a brief description of the job, like, oh, dishwasher is someone who washes dishes and da-da-da-da. Okay. I'll give a brief written description, and then it will break it down into, generally speaking, what are the physical demands of the job and what are the mental demands of the job. And those really sort of the three things that it does on a base level. Now, I know we can get into more, and that's what I wanted to ask you. So we know that it is a book, and you would never buy it as a book. You would just go online and look at it. So we know that.
Yeah. We
also know that it breaks it down into this sort of scientific language. And I wanted to talk to you about the language that either, if you're a young rep who's going into a hearing for the first time, what do these words mean? Or if you're, trying to go at this by yourself and you hear the vocational expert talking. And I want to first talk about sort of the physical demands of the words that they use to describe the physical demands of the job in the Dictionary of Occupational Titles. And so what I know is it's less than sedentary, sedentary, light, medium, heavy, very heavy. And if you could go through a brief definition of those words, because they are legally defined by Social Security, and people can Google it, but just maybe take me from sedentary up to heavy.
Sedentary. I have 4 kids in Catholic schools, so there's Latin going around this house. Sedentary is from the Latin sedes, meaning seat. It's work you can do seated. If you cannot spend, for medical reasons, more than 2 hours out of an 8-hour shift on your feet, total standing and walking, should not lift more than 10 pounds occasionally, which is up to a third of the day, or 5 pounds, about the weight of a half gallon of milk, most of the time, regular basis. That's the limit of sedentary. If you can do that much, you can do sedentary work.
What would be an example of a sedentary type job?
It's mostly desk work and bench work. A receptionist is sedentary for the most part. Somebody who does assembly work with small parts, sorts fruit on an assembly line, something where you don't have to spend much time on your feet. A lot of people work in call centers are sedentary, or if you got a job looking at screens, sedentary. Anything you don't have to spend much time on your feet or do much lifting at all.
And then the definition, so that's kind of the physical, almost the lowest level physical. I mean, there's less than sedentary, and we can talk about that in a minute. But then there's light. What's light duty?
Light duty is the next step up. You got to be able to spend 6 hours out of an 8-hour shift on your feet, standing and walking combined.
So not all at once, not 6 hours at once. It's combined. So you mean
that's right.
Stand for an hour, sit for 10 minutes, stand for an hour, sit for 5 minutes, stand for, yeah, I get it.
That's right. And all standard work has breaks, and I'm sure we'll talk about that in a minute. But you shouldn't have to lift more than 20 pounds occasionally, once in a while, up to a third of the day. That's the weight of a case of soda in aluminum cans or water in plastic bottles. 10 pounds frequently. Now, because it's work that's on your feet all the time, we're starting to get into a spectrum. I heard an expert last week talk about seated light duty work. That's work where the person can't spend 6 hours on his feet, but his upper body remains strong. He can lift 20 pounds if he needs to, get up maybe, or could do it from a seated position. But he's strong enough that he's not limited to sedentary work. There are plenty of jobs that an expert will say, that guy can only spend 4 hours a day on his feet. But look at all these jobs that fit into the light category where you don't have to spend 6 hours on your feet. So that's where sedentary is the bottom rung. Once you get up out of that, there's gradations of it, and it becomes important because you're trying to, winning some of these cases is like putting together pieces of a puzzle.
Right. What would be an example of a traditional light duty job?
Okay. A lot of light duty jobs are office jobs. You wouldn't think about it, but there's a lot of people who have to spend a lot of the day walking around in an office or carrying boxes of files. If even once a day you'd have to pick up a box of files, that's more than you should do in sedentary work, and you're starting to get out of the sedentary category. A lot of office work is light. A lot of cashiering work or checking work, retail work is light work, because even though you don't have to be on your feet, you're kind of standing up and dealing with the public. You're moving their stuff around on the belt, for example. And so it's more than somebody who doesn't make any sort of exertional use of their upper extremities, and they can't really be sitting at a desk. So that's edging up out of light work, is office work and cashiering work. Then there's a heavier end of it. People are on their feet almost all day, just not doing a lot of heavy lifting. Waiting tables, because I used to do that, is the example that comes to mind. Tending bar, for example. You're on your feet all day, and you got to lift some heavy weights sometimes. And you got something in your hands all the time, but it's not really heavy, so it's not medium work yet.
Well, that brings me to my next question. When the vocational expert or the dictionary of occupational titles talks about medium work, how does Social Security define medium work?
6 hours a day on your feet, standing and walking combined, like we talked about. But now you have to lift 20 pounds regularly, 50 pounds sometimes. This is generally a guy who's going to be a person who's going to be lugging a toolbox up and down a ladder, for example. These are generally people who, you're starting to get into people who work in the trades. They might be in the construction industry. They might work in industrial production of some kind, metal fabrication people, auto mechanics, people who have to get into different places. So you're using tools that require, good strong hands and arms. You're probably going to be lifting stuff that you wouldn't lift in an office or a retail setting. Just more exertion.
Maybe the bar back who has to lift the kegs.
I always did that myself, but yes, that would have been nice if I had a bar back. Yeah. Because anyway.
Or a chef or a cook who's lifting food orders or food boxes and things like that as examples of jobs. What about how do they define the word heavy? So if I'm a claimant or a young lawyer and I hear this word heavy, what does that mean?
50 pounds regularly and 100 once in a while. And 100 pounds is heavy. If you have to lift 100 pounds a few times at work every day, you're working all day. Yeah. This might be lifting bundles of shingles on your shoulder up a ladder, for example, on a roof. A lot of these people are, kind of gophers on construction sites and so forth. And there's that balance. I'm sure we'll talk about skills in a minute. There aren't many really heavy skilled jobs. There are some, and they're very interesting jobs. But you're starting to get up out of, that's a person who's making their living with their back.
Yeah. How about very heavy? You hear that term too?
I don't, when we were thinking about this, I don't know if I've ever heard somebody testify about a very heavy job. It's over 100 pounds.
Yeah.
And most people who have to lift more than 100 pounds now will have some kind of equipment to assist with that. Although you and I have both heard about people in medical settings who have to move very heavy patients. So.
Yeah. You talk to nurses and, orderlies or, whoever have to lift those, very, very heavy patients. I think, and even on some construction sites, you're still getting guys that are doing like construction cleanup that will lift multiple boards at the same time and kind of keep up with the pace of trying to clean up a spot to get into that very heavy range. I think it also depends on how you fill out that form. If you're like 100 plus pounds, vocational experts going to see that and see like, okay, I believe that you had to do that at the very heavy range because of the nature of the job. Now, if you come in and say, I was working as a telephone solicitor and it was very heavy, they may question that quite a bit.
Right.
The other thing, too, is the Dictionary of Occupational Titles talks about skill level. And a vocational expert will talk about the past relevant work, what the job title, the number, the DOT. And now you talk to us about the physical demands of the job, sedentary, light, medium, heavy, very heavy. And then assign it like a skill number, and they use this word SVP and then give it a number. Can you tell our audience what that all means, the SVP and, and kind of walk us through in the same way you did with the physical, unskilled, semi-skilled, and skilled, and maybe define those for us. And let's start with unskilled, SVP.
Unskilled. SVP stands for specific vocational preparation. That's skills that you learn to do a job. Might be running a register, might be using a particular tool. It might be a huge body of work like how to run a nuclear plant. So SVP is skills. SVP 1 and 2 are the very entry-level jobs that you don't have to have. You can learn them easily in 30 days. You may not have to know how to read to do it. You may not have to have great English to learn how to do it. It's jobs that you can watch someone do and then do yourself within 30 days. I think that's exactly right. That's exactly right. And as a consequence of that, a lot of these jobs don't require much in the way of communication with other people. So you'll also hear us talk in that part of the testimony about simple, routine, repetitive jobs. Those are jobs that not only does it not require much skill, you're doing the same thing all the time over and over again. Yeah, so
right. And routine.
Right.
And what about semi-skilled?
Semi-skilled jobs, okay. Skills can be acquired. A skill is a set of knowledge, something you can do that confers on you some advantage over other people in the workplace, something you can do that other people can't. You can acquire skills by doing the job or by training and education. So if you're starting to get up out of semi-skilled work, you might have some sort of certificate in nursing, something you had to go to school to learn how to do. You might have experience, taking a step up the ladder at a retail establishment. You might get the keys to the place where you work where you didn't have them 6 months ago, where you're starting to get a set of skills that other people can't do. Semi-skilled is when you can learn that in about 6 months, sometimes a year, but really about 6 months. You're starting to take the first step up the ladder as semi-skilled. And there are gradations for that. When we hear SVP 3 and 4, that's people who are semi-skilled is when you got something that a lot of other people don't have, but there's still other people who have got more than you.
Yeah.
Beyond that, you're generally starting to see somebody with more than on-the-job training, but that's SVP 3 and 4, semi-skilled.
Maybe like a receptionist job in a law firm, or entry level or not entry level, but I'm trying to think like an assistant, not necessarily a legal assistant, but an office assistant, and then there's skilled. You'll hear the word skilled, and what does that mean?
Skill is anything that you can do that other people can't. You've learned to do something that because you can do it and others can't, you've got a leg up at work. You've just given a couple of good examples of what that looks like in light work. You got to remember there's all sorts of other skills too. Somebody who's at SVP 3 or 4 might be an apprentice plumber, might be a guy who is a butcher working on becoming a meat cutter. Might be a guy who is, he's a stone he mixes concrete and he gets it right, but he's watching the mason while he's doing it. So there's a lot to that doesn't have to do with school, and you're right that's something you got to be careful about, especially we'll talk about transferable skills, I'm sure.
Well, I think of the beautician, the person who cuts my hair or your hair. They have to go to a beauty school, get licensed and certificate, and they're on their feet all day using their hands. So it's not a simple sedentary job. You'll hear, what's the highest SVP number that you'll hear? It's 9, right?
I don't know if I've ever heard a 9. You hear an 8 once in a while. I think you and I are 8s. We might be 8s.
You know who's a 9?
Who is?
SSA Judges.
Dan Hyatt is an. Oh, that's fantastic.
I asked what is the SVP of a Social Security judge? 9. What is it of a Social Security lawyer? 8.
Right.
and so it was a big, there's a big laugh in the hearing room about that. So,
That's
yeah. Anyway, so we talked about the DOT, brief description, number, physical demands, mental, preparation, the skill levels of that job. Just because, let's say and one thing I wanted to highlight on the skill level is that you actually have to, for it to be considered past relevant work, you have to achieve the skill level for it to count. So, for example, if you are an SVP 5 or 6, and you only work at the job for 2-3 months as your job title, in my experience, and I'd like to talk to you about this real quick. In my experience, most vocational experts will say, yes, you were a paralegal, but you didn't have a certificate, and you only worked at the law firm for 2 months, let's say.
Yeah.
And what will they say to that?
Well, that means if you have not practiced that job, you have not acquired the skills. And I'm going to tell you, I think of this as an evidence question, because if you try and do a job that takes 6 months to learn and you last 4 months at it, that probably means you can't do that job.
Right.
And so, if you have a hard time with the expert about it, sometimes you reopen your own testimony and say to the guy, hey, when they said that you had that job as a manager, how did that go for you? What kind of problems did you have?
Right.
So the expert's got to have a basis for their opinion too. And sometimes they make a mistake that way. That's why you got to be careful with your client's work history, which I think is something we talked about a minute ago.
For form and function, in the hearings that you've been in, does the judge go through in the testimonial part, job by job by job by job, and ask or re-ask to describe all the past relevant work that the person has done in the last 15 years at every hearing? Like, should a client or a claimant or a young lawyer be prepared for those types of questions? Like, literally going through every job you've done in the last 15 years and asking you, what did you do there? How much did you lift? And how long did you do it? And what did you learn?
You have to, okay, this is a good practice point for any sort of professional. Do they do it? Generally not. Should you be ready for it? You had better be.
Yeah.
And you had better make sure that your client is. Because if they're doing it, because some judges always do, point by point, they get the earnings records out and say, what did you do at this job where you made $6,200? So a lot of judges will do that. If a judge who doesn't usually do that starts doing that, that means there's a problem with your case. And so, like I said earlier, you better be ready for that.
That's right. And as a young lawyer, or if you're not represented, be prepared. Look at your work history, not just the work history form you filled out, but there's also what's in the exhibit file is what is called a detailed earnings query. And that will show all the work you've done in the last 15 years by job, by job, by job that you paid into taxes on. Now, every once in a while, we get clients, and more often, not just once in a while, but often we'll get clients who worked under the table. And that actually does count as your past relevant work as well. So the judge will ask, did you work that year under the table? And you can't lie. And so if you say yes, that's fair game as past relevant work if you did the job. And you do see that in some more construction jobs. Doesn't mean it hurts you. You don't need to be ashamed. They're not calling the IRS after you. None of that. They're just trying to get your work history and fully understand what you have done. So after they go through the work history, and then we said, okay, look, here's your past relevant work. Now they're going to get asked a series of hypothetical questions. My experience, the judge always goes first with this. The judge not always, 95% of the time, the judge will ask the vocational expert questions first, and then we're allowed to cross-examine. So if the judge does want to go job by job, that will happen up front. And then the judge will ask a series of hypothetical questions first. Generally speaking, Jack, from your experience, and you've been in front of hundreds of judges, how many hypothetical questions on average will a Social Security judge ask of the vocational expert?
3 or 4.
3 or 4.
Sometimes 5 or 6. I had one judge ask 13 once, but he was keeping count as he went along and kind of laughing as they added it up. And you can tell a lot. I mean, that's the best way to get aim at what the judge is thinking about the case is the questions they ask at the end. 3 or 4 is about right. Complicated cases could have more. Cases that are a clear call or just one big issue might be 1 or 2 questions.
And so let's say, because the law says, and I want to talk about people between the ages of 18 and 49 or under 50.
Yep.
The law says we have to, and generally speaking for everyone, we have to prove you cannot do your past relevant work, which we just defined, all the work you've done in the last 15 years. And now, if you're under the age of 50, we have to prove you can't do any other work that exists in significant numbers in the national economy. I personally think significant, and this is based off federal court work, significant numbers is around 30,000, give or take. Okay? It's arguable in federal court. Now, but other jobs, meaning so I'll say this again. The claimant's duty, if you can prove you can't do your past relevant work, you have to prove that there are no other jobs that you can perform in the national economy that exist in significant numbers. Well, Mr. Evans, I was a surgeon. I'm 48 years old and I was a brain surgeon. And I have a hand trimmer. I'm sorry, but we have to prove you can't be a parking lot attendant. And that is the standard of the case. Now, the judge will say, can they do the past relevant work? Vocational expert will probably say, maybe no. He has a brain surgeon, he has a trimmer, he can't do the past relevant work. Are there any other jobs based off of these hypotheticals that this person can do? Hypothetical number 1. Now, you gave some hypotheticals. Let's tear those hypotheticals apart. So you ask, if I'm a client of yours in a hearing, and I hear one where like, yes, there's other jobs. Here are the 3 sedentary jobs that they can do. Should I become flying out of my seat? Jack, there's no way I can do that job.
No, you should not do that. You should let me and the judge do the, when I used to do a lot of criminal trial work, and you've got the guy sitting right next to you, and I used to have to say, shut up while I work, please, But no, the answer is no, because the judge is going to ask a bunch of these questions. And the first one, should we talk about what the DDS opinion is? Because that's usually...
Yeah, a little bit. We don't need a deep dive into it, but just kind of where it comes from.
Right. By the time that you get to a hearing, shortly after you apply, in fact, Social Security has already evaluated the medical evidence in this case to see if you're so catastrophically ill or injured that nobody thinks you're ever going to work again. Don't make that poor guy wait for a hearing. Pay the claim, please. But is it like 80 something? It's almost 90% of cases get turned down. That
depends on, yeah, we can. Yeah, it depends on. It's a little less than that, but yeah,
right. That opinion stays in the file. The agency that formulates that opinion is called Disability Determination Services. So we call that the DDS opinion, and generally, it's included in your file because Social Security has come up with an evaluation of your abilities. And a judge will generally ask a question about that at the hearing. It's usually the first question. Now,
first hypothetical.
The first hypothetical question, that's right. Now, as you said, a lot of clients are pretty upset about it because, I used to be a bank manager and this guy wants me to run the Zamboni at an ice rink. I can't do it, So I say to them, that's kind of the throwaway question on the test. The judge could pick that question and use it to decide your case. But you got to remember, we know a lot more about your medical conditions. We filed a lot of evidence. The judge is the first person who's really taken a look at you and spoken to you about this. Don't freak out about that question. There's more coming up.
Yeah, I heard a judge who I had a lot of respect for even tell a client in the hearing, he's like, hey, listen, I'm going to ask about 3 or 4 hypotheticals. The first one is going to be Superman, right?
Yeah.
Make it sound like Superman. Don't come out of your seat. We're just going to I got to do this for legal purposes and kind of make sure, the judge, the auditors of whoever I make a decision, the auditors of my decisions, I need to be asking these questions. The first one's going to be Superman, and the other one is going to be like Lazarus. So you're, don't come flying out of your seat. Your lawyer will explain it to you. And I thought that was a kind of a good way to explain it. In a sense, yes, in my experience, the first hypothetical is the most unrestrictive, the least physically and mentally limiting, the one that got you denied in the first place to get there.
Right.
And judges are not bound by that decision, but they ask it anyway as a hypothetical. And then there's and then the second and the third and the fourth hypothetical get to be more limiting. This is why, and I chuckle at this every time I say it, because part of me knows it's like I'm self-interested as a lawyer who does this, but it is why you should hire a lawyer, right? Yes, because the judge is very interested, and at least in my experience, most judges are very interested in the hypothetical that you formulate, Jack, because where do you get that out of the record? And if they don't think if they think this is fantasy, if a judge thinks you're creating a hypothetical based in fantasy, meaning not on the medical records, they're going to ask, Mr. Cahill, where do you pull this limitation from? And being as well prepared and as experienced as you are, you will tell them.
That's exactly right. I did that to a judge this week, actually. Where did you get that? The EMG, because it was very restrictive. It was on this client's hands. He had problems using his hands. And the judge said, where did you get that? And I said, he had an EMG at this hospital on this date, Your Honor. You'll find it at Exhibit 6F, page 144. And that's why he's reporting all this pain and numbness in his hands, Your Honor. You can see the scores on the test.
Awesome.
So, yes. Right, and that's the poor guy leading with his chin. I mean, he had the same exhibits I did. He just didn't look at them as carefully.
Yeah, I mean, and it's they are so overworked. I mean, I have a ton of respect for the judges, but they have to do 5 hearings a day.
Yes, they do
5 days a week, and having a representative or having some experience in training and understanding how to read a medical file and creating hypothetical questions for the judge actually helps the judge. It's not necessarily combative. Would you say the vast majority of your cross-examination with a vocational expert is friendly? Yeah, I mean,
we have to see these people all the time. I always mind my manners anyway. And to clarify, the judge, when I was able to say, "Here's a site, Judge," she laughed. I wasn't combative with the judge. I'm not there to be.
Yeah.
Unless I need to.
And because you knew the file and you were able to formulate a hypothetical from the file, you likely won the case for that client just in that moment.
I hope so. And that's, we're trying to lead the judge. When you did criminal work, if you wanted a judge to enter an order, you'd write the order beforehand that you want the judge to sign and bring it to the hearing. And when the judge said, okay, you hand him the order. If I give the judge a limitation that will win my case and say, here's where I got it, Your Honor, that's likely to show up in the judge's decision.
Right.
Yeah. So I guess that's a practice point.
I think the last kind of topic, and we've been talking for a while now about this, but the last sort of thing I wanted to chat with you about is I asked you, and we had talked about, okay, if you're considered, quote unquote, a younger individual, which is a legal definition, someone between the ages of 18 and under the age of 50, so 49, you're considered a younger individual. And in that, the law says, you have to prove there's no job basically in America, in the national economy, that you can do that exists in significant, or that you can perform in significant numbers, right? It has to exist in significant numbers. And that's tough for some people to swallow, like professionals. I meet professionals, especially like, oh, I was an accountant, I was a CPA, I can't go be a parking lot attendant. Social Security doesn't care about pay discrepancies from a CEO at 30 to a parking lot attendant at 30. If you can be a parking lot attendant, you have to go do that, before you're eligible for Social Security disability benefits. Like, you have to prove you can't do that job full time. Now, this is where when I talk and train young lawyers, this is the area that they mostly get tripped up in. So that's why I talk we're talking to clients, potential clients, or, but I also would love for you to talk about sort of the different age categories over the age of 50, right? And maybe break that up. What are the different age categories from 50 to 54, 55 to 59, and 60 plus that you deal with almost on a daily basis, I'm sure, in your hearings?
The grid rules is what we're talking about.
Yeah, for sure.
Right. Okay. If you are, once you turn 50, like we talked about, under age 50, you got to eliminate all jobs in the U.S. economy.
Yeah.
Once you turn 50, and the reasoning behind these rules, the older you get, the harder it is to get a job. And so Social Security allows for the fact that people who might be past entry level should be able to leverage the skills that they've acquired. So it becomes much more important to determine whether you can do some sort of skilled jobs that you already know how to do and can physically and mentally bear. Do you have some physical skills? Before I was 50, I used to explain it this way. I've been a lawyer a while, but if I had a head injury and I couldn't practice law tomorrow, the judge would say, "I'm sorry about your head. You've got two, strong back and two hands and two eyes. Go find a job." Right. But once you turn 50, it becomes much more important to determine whether you can physically and mentally bear that kind of work. Grid rules.
Well, before you jump into the grid rules, let me ask you this: what do the vocational experts call people that are between the ages of 50 and 54?
Is that advanced age?
Closely approaching
advanced age. Right.
And then 55 to 59 is advanced age.
And over that is approaching the retirement age. Right.
Yes. So there's 3 age categories after 50: closely approaching advanced age, and closely approaching retirement age. And it's important because and just from a big picture standpoint for potential clients or people who are just listening, clients that, I guess not lawyers that we're trying to train, but the older you get, it becomes a little bit easier to win your Social Security disability case. Right. If I was just to give it a blank general summary, right? So yeah. So now let's talk about the grid rules, because we've spent a lot of time talking about the physicality of the job and the skill level of the job. And one of the things they'll talk about is, in a hypothetical, is if this person is limited to, let's say, sedentary work at 50 to 54, what becomes the issue?
The issue is transferable skills.
Right.
Okay. These grid rules, they lower your burden of proof when you turn 50. And if you're limited to sedentary work, a good example is a guy who works in the trades, some sort of heavy outdoor work, maybe heavy equipment, construction, something like that, and acquires a lot of skills. He's, if he's 50, he's been working in that job maybe 30 years. And so he knows what he's doing and has moved up the ladder there. And he has some sort of bad injury. And he can't operate this machinery. He can't be in and out of these places, climbing up of the cab of a piece of equipment, for example. The question becomes, well, has he acquired skills that he can transfer to work that he can do? If a guy is a stonemason and he hurts his back or develops arthritis and he can't do that heavy sort of work, well, we can't send that guy out to lay a pallet of stone. Could we make him an estimator? Could we, is there something in the office he could do where we're not just throwing away this body of knowledge? Is there something left that he could do even though he can't do the heavy aspects of the work?
Right.
If you have skills and you're less than 50, you can go learn another trade. But if you're 50-something years old and you can't do your work anymore, nobody's sending you to school.
Right. So between the ages of 50 and 54, it's called closely approaching advanced age.
Yeah.
The very first element of that, to get out of the burden of proof of proving there's no job that exists in significant numbers in the national economy you can do is that you have to physically be limited to sedentary work or less. Okay? Because if you're physically limited to light duty between the ages of 50 and 54, as we defined earlier, then the burden of proof is still the same. Are there no light duty jobs in America that exist in significant numbers that you can do? But if you're physically limited to sedentary and the judge believes that you are, and the judge believes based off the evidence, okay, there's no way this guy could do light duty, medium, heavy, or very heavy. So they're limited to sedentary. We don't expect this 50-year-old to go get unskilled work, but what are the transfer and the question that comes to the vocational expert, if you're so in that sedentary category, what are the transferable skills that this person picked up as a crane operator or a heavy construction equipment operator that transfers to a sit-down job that requires lifting less than 10 pounds? And if the vocational expert says, oh, here's 3 jobs, then it's likely the claimant's not going to win. But if the vocational expert says, which is always music to my ears when I hear it, there are no transferable skills, I don't even ask any more questions, right? Right. So then we know that client 1, at least as they're the day before their 50th birthday, and there's no transferable skills. But again, if it's light duty, if the judge thinks, I think this person can do a light duty job, then there are no, then the burden of proof stays the same as if you were under the age of 50, but the vocational expert has to provide light duty jobs, which they can do pretty easily. Right. But at 55 to 59, in that age category calling advanced age, at light duty, even if they limit it to light duty, it's like the burden of proof changes because they have to say what transferable skills to light duty even. And so that's where, as you get older, it becomes easier because you don't have to prove you're limited sedentary at 55. You can prove you're limited to light and still win, especially if you had a medium or a heavy duty job. And then when you're even older than that, at 60, do you know what the rule is at 60 or closely approaching retirement age?
If the skills transfer, it's light with skills that transfer with minimal vocational adjustment. Is that the phrase?
Minimal, basically, you got to do a job that's almost like the job you used to do, right?
Except so maybe easier.
Right. Yeah. So if you can get rid of, and in all cases, whether you're 60, 64 or younger, you still have to prove you can't do your past relevant work. That doesn't change. That element of the law does not change. So what we're talking about is step 5 of the sequential evaluation, which is other work. And so the transferable skills at 60 plus, before full retirement age, is that you basically got to prove that there's no vocational adjustment in the same basically realm and field of that you used to do. So, when we look at 60-year-old plus clients, that's one of the big things we look at is like, okay, this should be, I hate to say the word slam dunk, but as long as we can get them out of their PRW, we should be okay.
Right. You don't have to beat 13,000 jobs in the DOT. You've got to beat maybe 1 or 2 or 3 jobs.
Right.
And they all look like the job you already beat.
I think it's one of the more complex areas for young lawyers to understand. And then there's charts and grids and quote unquote grid rules. And I think I don't want to deep dive into it too much more, but I do want to kind of ask you this. Is there a frequently asked question that clients ask you about the vocational expert? I have one that I can think of. And it's not just about the vocational experts, it's about experts in general. And I'll start with mine and you can answer it.
Yeah, you go ahead, because when I prep a client, I usually do a pretty thorough explanation. But go ahead and I'll think.
Yeah, so the one question, and sometimes I proactively answer this, kind of when I give my spiel on how to prep for a hearing. But the one question that I get is the expert going to ask me any questions?
Oh, yeah.
I don't know if you get that very often, but every once in a while, the most common question is, as a client or a claimant, do you think the vocational expert or the medical expert will ask me any questions? How do you respond to that?
The reason I don't get that question is because I cover that when I explain what the witness does. This expert may ask you one or two questions. If they do, here's how I think you should. So, but yeah, and part of that is advice on, part of that is general advice on how to answer questions for any witness. And a lot of it is what we've already talked about. Give a look at what we've already filed for you. If you're representing yourself, give a look at the earnings records that you have access to. We call them the D exhibits, and just be ready to answer questions about these issues that we've talked about. Could you sit, stand, and walk enough to do your job? Were there any special skills your job needed to do or physical requirements like heavy lifting or ladders? Go through and be ready to answer questions about that. Because they're all stuff that you really should know because you told us you did these jobs. Make sure you're ready to answer basics on what you did at these jobs and problems you had doing the jobs.
Yeah, that's a great way to answer it. I think the answer is yes.
Yeah,
An expert witness could potentially ask you questions. I smile at this, though, because as you and I both know, every judge is a little different. Like the more kind of seasoned or older judges that are kind of like, let's get through this quickly, we'll just say, okay, vocational expert, go ahead and ask your questions of the client.
Right.
You get a younger judge who's brand new to it, will be like, no, you ask me, tell me what you want me to ask them. And then the judge will basically like repeat what the vocational expert says. So technically the vocational expert's not asking you the question. The judge is asking you the question. It's a silly thing. I mean, from just how people talk to each other. But I do know judges that will not let the expert witnesses ask questions directly to the client because they want to filter the questions, through them before they ask the claimant the question.
To be fair to the judge, anybody might ask an objectionable question.
Yeah.
Anybody might ask a question that the witness should not be required to answer. So that's to be perfectly fair to the judge. To be fair to everybody else, let the guy do his job.
Yeah. The last thing I'll say, kind of about this subject as we close out here is that I think the thing about vocational experts, the transferable skills, even federal court says it's an art, not necessarily a thing that is, set in stone. So if a vocational expert comes up with like, oh, people skills, that's the stuff that drives me crazy. Yeah. And so sometimes that's where knowing the vocational expert is really important, knowing what they're gonna, what they might pull out of nowhere as far as what is a skill. And the other thing I wanted to say is that if a judge does ask you, or a vocational expert does ask you a question, 99.9% of the time, in my experience, it's been about your past relevant work. They were looking for clarification. Did you do this full time? Did you do it part time? How much weight did you lift? And that's why, before you go into a hearing, we send our clients the work history form that they filled out so they can be consistent with the things that they've already told Social Security. So, Jack, any last closing words that you might want to say regarding this vocational experts topic?
Every once in a while when I prep one of these cases, it's like we talk about in a couple of the segments we've done here. There's a lot to this. We do this all the time. Every once in a while, I'll say to a client, I could actually prep you to follow all of this testimony. You're going to hear a lot of scientific testimony, and some of it's plain English, and some of it's 9-digit numbers, and some of it you'll get, and some of it you won't. I could prep you to follow all this stuff. It might take a year, though, and then you could put on your own case. So this is the kind of thing we do all the time. And I just, I hate to think about people who lose their benefits because they don't see something that a lawyer would have seen if he'd picked up the file. That's what I think about that.
I agree. Oh, man. Having a little bit of a cough here. So thank you so much for your time. I appreciate it.
Always a pleasure.
Cough it like brought me to tears.
great, valuable information regarding vocational.
All right. Always
All
good
right.
to talk to you, Peter.
You too, Jack. Take care.
Thanks. Yep, you too.